Okay. So this is case number 2401653 GC Calvary SPV1 LLC versus Tarina, Tarena Ingram.
Good afternoon, Your Honor. Jeff Warber, P67124 on behalf of.
All right, Mr. Warber, good afternoon. Ma'am, what is your name?
Hello, Your Honor, Tarena Ingram.
All right.
Thank
And
you.
good afternoon to you.
Good afternoon, and thank you for hearing this case.
Well, no problem. We have to do that. All right. And so today, from my understanding, I don't have a separate, submission with respect to this matter. It's my understanding that this is a Judge Arvant case and that there was a ruling on a motion to disqualify the judge, and she denied it for some reasons that she stated on the record. So I don't have a transcript of that. But you've asked me as Chief Judge to review the whole situation, pretty much de novo, as to whether or not Judge Arvant should be, in fact, recused from the case. So what is your basis that you're claiming that she should be recused from the case?
My basis is I compelled the motion, the date of the deposition, to compel to arbitration per the credit card agreement. I stated that I could compel arbitration at any time as long as there wasn't a default judgment or a trial started.
Okay.
So I did.
So this was a credit card debt.
Yes.
With the plaintiff, Calvary SPV now. And you're saying that whatever the agreement was on the underlying debt involved an arbitration agreement.
Yes.
And you're saying that that agreement specifically said that you could request it at any point in time.
Yes.
Okay. So what is the basis for the recusal of the judge?
She denied the motion in each of a default judgment.
Ladies and gentlemen, today's courtroom showdown is a perfect example of what happens when someone confuses disagreement with discrimination and a legal loss with judicial misconduct. At the center of this case is a defendant who owes a debt she openly admits exists. Yet, instead of focusing on the legal issues that actually matter, she's attempting to remove the very judge who ruled against her. That's right, rather than appeal the ruling through the normal legal channels. She's asking the court to believe that the judge must be biased simply because she didn't get the outcome she wanted. Now, before we jump to conclusions, let's be clear. Judges absolutely can be removed from cases when there is genuine evidence of bias, prejudice, or misconduct. The judicial system takes those allegations seriously, but the key phrase here is evidence, not frustration, not disappointment, not the feeling that things were unfair. Actual evidence. As you'll see throughout this hearing, the chief judge repeatedly tries to explain a critical distinction. There is a massive difference between a judge making a ruling you disagree with and a judge acting with actual bias. That distinction becomes the entire battleground of today's case. Watch closely, because the more questions the chief judge asks, the more difficult it becomes for the defendant to identify anything resembling judicial misconduct. Instead, the conversation keeps circling back to rulings, procedures, and legal decisions that belong in an appeal, not in a motion to recuse a judge. By the end of this hearing, the court will have to answer one simple question. Was this judge truly biased? Or is this simply a litigant refusing to accept an unfavorable outcome? Let's find out.
So now you do know that there is a specific rule that outlines when a judge can be disqualified. So you're going to have to meet the standard under that rule. Now, typically, if a judge just takes an action on a case and you don't like it, that's an appealable issue to the higher court if you wanted to do that. But I'm not sure that that means that she should be removed. You have to meet the standard for disqualification. So what other than her ruling, what is it?
Well, it was unjust, and this lawyer attorney violated a lot of my rights. The debt was only $1,877. I never denied the debt, but this attorney never served me. the original summons. Never served me.
Okay, but I can't, no, let me tell you what I can't do.
Okay.
What I can't do, because Judge Arndt is in charge of her rulings on
Yes.
her case. So I can't go back and change her ruling on the
Yes.
facts or the law. What I can do is decide if there was anything in the circumstances of what she did that would point to a reason to have her removed from the case.
She showed favoritism to the attorney from the
And how
beginning of the case.
How was that?
She made biased statements,
Such as?
when I told her that I mentioned that I never received the original summons, she said it didn't matter. You were put on notice with the alternative order that I signed.
Was that alternative service?
Yeah,
So what we call alternate
a
service?
second summons or alternate summons.
Oh,
Alternative order or,
so it sounds like you're saying that she's basically saying if you didn't personally have it, that alternate service would satisfy it. So that's a court ruling. How does that show bias?
it's just statements that she made. She didn't, everything that I said, she didn't hold him accountable for anything. She didn't ask him anything. Well, what steps did you take to serve her? She just showed him favor. He said that, Your Honor, you know me. I've been in your court before. He made oppressive statements, and during the mediation on the Zoom video, the judge is going to enter default judgment against you. He said it several times, like threatening and abusive and oppressive statements.
Okay, that's what he did though.
Yes.
So here's the thing. The rule really sets out the kinds of things that the judge has to do. This is a pretty high standard to get somebody removed. And I understand you might not like the way she ruled on something. And it could be the case that you don't understand how she applied the law on some things. Because I will say this, and I'm not commenting on the validity of her ruling, but I can tell you that alternate service is usually given by court order when someone has had trouble personally serving. And so that is considered good service under the court rules.
Yes.
So I don't know if there was something wrong with her ruling there, but I can just tell you that pretty much is normal. And if you're following the rules, if the judge is doing that and you don't like it, the real remedy is to appeal it and see, not to me, because I'm not a judge, but appeal it to the next higher court if you think that there's something legally wrong with what she did.
Right.
Because, for this, you have to have real specific facts of how the judge would be biased or prejudiced. What is it she actually did other than just ruling on the motions or ruling on your request or saying things like, well, it doesn't matter because you got alternate service. That's not a bias. That's really stating what the law says.
Right.
So you have to have a really good reason to show bias.
But it was my third motion, the third one. She already listened to the disqualified one and she denied that.
Right, and that's what you're appealing to me, is her denial of that.
I'm appealing the default judge.
This is the first major turning point in the hearing, and it's an important lesson for anyone watching. Notice how the chief judge keeps steering the conversation back to one specific issue, evidence of bias. The defendant repeatedly returns to arguments about service, debt collection practices, and procedural complaints. Whether those complaints are valid or not is almost irrelevant to the question currently before the court. The judge isn't being dismissive here, she's drawing a legal boundary. Appeals deal with potentially incorrect rulings. Recusal hearings deal with potentially biased judges. Those are two completely different legal concepts. The problem for the defendant is that every example she's presenting sounds more like an argument that the original judge made mistakes rather than an argument that the judge was prejudiced against her. And unless she can bridge that gap, this motion is already facing an uphill battle.
I can't do that. You have to go to circuit court to appeal her ruling on the set-aside default. The only thing I can do is say whether she should have removed herself or not. That's the only thing I can do, because I'm not sitting as an appellate judge. The appellate judges are at the Oakland County Circuit Court. So you could have done one of two things. Probably you could have asked her to reconsider her ruling. And if there's nothing new you're presenting, then she may not reconsider it. The ruling might be the same. Or you could, within the time frame that's allowed under the court rules, you could file an appeal up to the circuit court. And they would have to look at it and see if she did something wrong, I guess, ruling on that
She
motion.
overlooked my complaints of the attorney violating my rights, my civil rights, and as a consumer, she overlooked that. She didn't look into that at all. She just overlooked it and just reprimanded me. She overlooked my rights being violated.
Okay, well, what rights were violated that caused her, that is showing some kind of bias?
Improper service, she didn't look into anything, the documents.
I thought we just went over the service part.
Well,
alternate service.
and then
It might be good.
the oppressive statements that he made during the mediation, to me, that's a violation of the Federal Credit Consumers Act, that a debt collector or whoever's not supposed to make oppressive, abusive statements to collect the debt. He said it several times.
Well, okay, so I don't know what you asked her to do because I have no transcript. No one has given me a transcript of what actually occurred. And I'm really hearing this de novo, which means from the beginning, as if you never did it over there with Judge Arvin. So I'm trying to understand, what is it? Now, let's just say he did what you said, and he said some oppressive statements to you. What about that causes the judge to have to remove herself from the case because he made these statements to you in a mediation? Which, and let me just say this, normally, whatever's done at mediation, we don't know anyway. We don't really get involved with these.
Okay.
That's called a settlement process.
Okay.
So we usually don't even know what happened at the mediation, of what, if there was an offer or not, and where they were, or how far the parties were apart, you know, what you offered them, what they said they would accept or wouldn't accept. We don't really know that because that's a settlement negotiation tool.
Okay.
But if you're saying he said something that you thought was offensive, what was it that you asked the judge to do? What was she supposed to do? And how does that show she was biased against you or prejudiced against you? Because it's a very high standard. What you're asking me to do is remove her from that case and have it reassigned to some other judge.
Okay.
And that's the only thing I can do. I can't look at whether she was correct in her ruling on something because that's an appellate.
Okay.
That's an appellate issue. But I can say if something she did seemed like it was rises to that level of bias or prejudice against you, then I would say that motion, if you're asking for her to recuse herself, then that should be granted. And then I would have it reassigned to someone else. Either myself, it's a blind draw, myself or the other judge could possibly get it. But you would have to meet that standard just on that. So unless she said or did something that shows bias, we can't worry about the actual ruling itself.
Okay.
If you understand the difference.
Yes, I do. Yes. She made a few statements. I mean, this happened a few months back. I can't recall everything, but I did write some things down. Like I said, she was showing bias favor towards him when he told her, "You know me, Judge." And she made a comment about, well, some people just don't like to be served. I think that was biased. That wasn't just for her to say that because he never served me. So she was automatically.
When you say serve, you mean personally?
The summons, yes.
Yeah.
And she said, well, some people just don't like to be served.